Hello and welcome everyone to yet another episode of Lawscope. In today's video, we shall be discussing the legal developments from the 1st June to the 15th of June of 2023. I'm Sana Parvez. I'm the legal expert for Hitbullseye, and without further ado, let's get on into the video. So we shall be discussing certain cases on varied aspects of law. The first aspect that we are going to discuss is in Kanchan versus Yogendra. This is a case of essentially the Transfer of Properties Act, which was adjudged by Justice Dipankar Datta and Justice Pankaj Mithil. This is a case wherein the Supreme Court essentially stated that will before the death of the testator or a general power of attorney cannot confer title onto a person. So essentially what all is required at the time of a sale deed of an immovable property under the Transfer of Property Act of 1882 is essentially that the conveyance has to be done between two living persons. Mind me, the word is that two living persons the conveyance has to be done, and the conveyance has to be done if the immovable property, the value of which is more than 100 rupees, then it has to be not just in writing, signed, stamped, etc., but also it is required to be registered by law. So essentially in this, what all is required is a lot of money of both the buyer and seller goes into one, paying the stamp duty, and secondly at the time of sale and purchase of in taxes essentially. So what happens is a lot of times the money, a lot of money goes essentially what the buyer and seller consider it as waste because it is going to the government. So here they try to evade sometimes this money, this certain amount of money, by circumventing the whole procedure, and the circumventing of this procedure was used to be done within 3 steps. So earlier people used to, in order to circumvent taxes, in order to circumvent the stamp duties, what they used to do was essentially follow a 3-step procedure, and this 3-step procedure used to involve an agreement of sale, an irrevocable power of attorney, and as well as a will. So firstly, two parties, say let us consider A and B. A is the seller and B is the buyer. The seller would agree, the seller and the buyer would get into an agreement of sale. Now agreement of sale is not to be confused with the sale deed, because sale deed is the deed at the time of which it is registered with the registrar properly, and stamp duty, taxes, etc. are duly paid on the sale deed. Here an agreement to sale is merely an agreement that I shall sell this property on so and so date, and this does not require to be registered. Now after 2001 it is required to be registered, but earlier with respect to all the conveyances before 2001 this was not required to be registered, and this was merely an agreement which could have been unstamped, but it was only required to be in writing. So the parties, the buyer and the seller, would make an agreement that I shall, the seller basically making a covenant that I shall sell this property to you on so and so date for so and so consideration. Eventually when this agreement of sale, which eventually confers onto the buyer the right to have this specifically performed, and gives a right in personam against the seller, and does not actually give a right in rem against the property. When this agreement of sale was concluded, then an irrevocable power of attorney would be basically made by the seller. So now the second step would be that the seller was going to make generally a power of attorney. So power of attorney is a paper, or rather it is a legal document or an instrument which states that basically generally an agency is created by the person who's making the power of attorney in the name of the person in whose favor the power of attorney is. So power of attorneys can be of 2 types. One is general power of attorney, and second is special power of attorney. Special power of attorney is only for a specific purpose, and general power of attorney is anything that is related to anything for a particular property or for a particular case or etc. So basically the seller would get into contract signing a general power of attorney in the favor of the buyer, stating that any decision that he has to take with respect to the property, for example buying, selling the property, dividing the property, giving the property on lease, etc., any decision whatsoever, he can do so, but at the same time it basically it's his prerogative to do so. The third step that he would do was that he would make a will, and in order to ensure that after he dies, the property goes to that person only, so that that person, it basically gives a right to that person to ensure that that person, the buyer in this case, has a right over the properties even after the death of the seller, and the seller's heirs do not ask for the property back from the buyer. So this was basically a 3-step process, and with these 3 steps, a lot of people started evading taxes and evading stamp duties, etc. But at the same time, in Suraj Lamp and Industries versus the state of Haryana, this is a landmark case of 2011. Basically, in this case, it was held that these kind of transactions which are done in order to fool the government, in order to ensure that the government does not get its due stamp duties as well as taxes, these kind of basically these kind of transactions are null and void, and they do not have any effect. So basically what happened in this case was there was a transfer that was done in the year of 2004, and this transfer, this sale and purchase was done following these 3 things: basically agreement of sale, irrevocable power of attorney, and subsequently a will. Now the buyer basically alleged that the property had been duly transferred, because he stated there was basically a change of possession also. The buyer got into the possession of the property, and the buyer was able to show the consideration proof also, that he had duly given consideration to this to essentially the seller. So now the seller basically filed a case stating that it is still his property and he has not sold it, and the documents of titles are still in the name of the seller. Here the Supreme Court stated very categorically that it cannot be so. A sale deed is a sale deed, and a sale deed is a document of title which is conferring on the seller, the buyer, any title whatsoever. Anything before it is not conferring the title on the seller, on the buyer. So here in this case it was finally held that if you try to evade taxes, then essentially what you're doing is trying to evade taxes and not getting into not executing a document of title. And if you're not executing a document of title, then the Supreme Court's hands would be tied, and the title will not have been deemed to be conveyed to the buyer. Let us see the next case. In the next case, the the Mumbai High Court stated that sex work is not an offence. Detention of adult worker for no reason infringes the fundamental rights of the person. So as we know that in India, prostitution is not illegal per se, but at the same time it is considered immoral. Essentially under the Contract Act 1872, it is not per se considered to be a void contract under it being forbidden by law, but it would still be considered to be a void contract because of the fact that it is immoral and it is opposed to public policy. However, having said that, it is still not an offence. So under section 17 of Immoral Trafficking Act, there are 2 aspects of it. One, soliciting these kind of services in public place, that is a criminal offence only because it causes annoyance in public place. So section 17 of the Immoral Trafficking Act considers it to be an offence if it is done in public spaces and not otherwise if it is done one-on-one. And secondly, anyone who's managing a brothel or etc., he is also guilty of human trafficking and immoral trafficking essentially. So he is also liable for certain kind of punishments. But In this particular case, there was a one-on-one individual case essentially, wherein the person, the woman, had been detained, and the woman was about 45 years of age, and she had kids as well. And in this case, taking care of what the law is stating, the Mumbai High Court stated that it is to be, the police has to be sensitized about the fact that whatever are the rights of sex workers. Essentially, last year there was a landmark judgment, Buddhadev Karmaskar versus the state of West Bengal. It was a Supreme Court judgment in which the Supreme Court elucidated the rights of sex workers. In this case, it stated that firstly, this kind of work is not an offence in India. The women have to be treated with a certain kind of respect. If the woman has to undergo any kind of assault of any nature, etc., then the police is not going to deny filing that an FIR, only holding that the woman was doing something immoral. At the same time, it has to be ensured that the woman is getting available rights under section 357C of the code of criminal procedure, essentially stating that if she's undergone any kind of injury in the process, then she has a right for fair compensation from the state legal service authority as well as the district legal service authority. Also, she has the right for it to be compensated by the man who has perpetrated the crime on her. At the same time, it has to be made sure that the police is duly sensitized about how to take care of these kind of activities, and at the same time, the removal of these kind of workers from against their will. Essentially, you cannot call shelter homes, and you cannot call basically shelter home as places of essentially imprisonment, and not allow sex workers to move in and around against their will. So a lot of times police apprehends people, and police apprehends essentially sex workers, and they do not allow them to move around. This is contravening Article 19(1)(d) and Article 19(1)(e), basically having the freedom or the fundamental right of freedom to reside anywhere where a citizen wants, and to basically move around anywhere that a citizen wants. Also, at the same time, the Supreme Court issued guidelines for the Press Trust of India to form guidelines about how to report on these kind of cases, and to ensure that the privacy of these women stays intact while making such reports. Next, we come to Jesse Jeevarathiram versus the Union of India. This is a case where there was a plea in the Delhi High Court against the adoption regulations barring the parents with 2 children from adopting a normal child. So essentially, if we talk about, this is essentially a case about adoption. If we talk about adoption is essentially implantation, taking one kid from one family and implantation of that kid to a new family, wherein once the child is adopted, then it becomes a part of the family of the say the new family or the adoptive family. So, if we talk about the adoption laws in the country, essentially, the Hindu Adoption and Maintenance Act takes care of the Hindu adoptions, and it has certain guidelines. It is not an adoption for the help of the child. It is essentially an adoption if a Hindu parent or a Hindu couple wants to adopt a child. So essentially, it comes from the fact that in the uncodified Hindu law, there was a need of adoption in case the couple did not have a son, because a son was realized to become like a pathway to moksha. At the same time, we now realize that the purpose of adoption is not only this. At the same time, we have to take care that the children who are in need of care and protection are also allowed to be adopted. Therefore, we made a secular act which is called the Juvenile Justice Act, which was recently amended, and a whole new act was introduced basically in 2015. In this, the cases have been divided into 2 parts: children in conflict with law, or juveniles is in conflict with law, and secondly, juveniles who are in need of care and protection. The juveniles who are in need of care and protection, there are a lot of remedies, there are a lot of basically things that could be done for them. For example, putting them in shelter houses, putting them in protection homes, etc. But also one remedy is the procedure of adoption that is given under these acts. Now, the procedure that is given has to be taken care by the CARA, that is the Central Adoption and Regulation Agencies, and in states it becomes the state agency. So the state agency, the state regulation agency, basically the state coordination agency takes care of all the adoptions in a particular state, but the regulations under regulations essentially of 2022 state that if there are already two adoptive children of a particular family, of a particular couple, then you cannot adopt a third child unless that third child has any kind of disability. Then you can adopt that third child. So freshly a petition has been filed under the Delhi High Court stating challenging the constitutional validity of this particular provision, wherein the third child, when a couple already has two childs which are so to say normal, it is going to only add value. If a kid is adopted, then it is only going to add value to the life of the normal kid, and therefore paramount interest should be taken of the welfare of the kid and not these kind of provisions. So this is the petition essentially that has been put up in the High Court recently. Next we go on to the Karnataka High Court judgment. The Karnataka High Court directed in Dr. Rajiv Giri versus the state of Karnataka. The Karnataka High Court directs employer to hold back the benefits of a woman until she hands over the baby to the husband. So essentially it is it seems at least so to be a very draconian judgment in which Justice Alok Aradhe and Anant Ramnath Hegde stated under section 25 of Guardians and Wards Act. Basically they stated as to what are the remedies that can be done and if one parent is not giving the child into custody. So if we talk about the custodial rights of the parents, they come under first of all the Hindu Marriage Act, the guards and essentially the guards and the Guardians and Wards Act, etc. So basically if we talk about these kind of guardianships and wards, etc., if two parents are separating, then as an ancillary remedy, custody can be demanded of a certain certain child. In the Guardianship and Minority Act, in the Hindu Guardianship and Minority Act rather, it has been categorically given the parameters which are same as the Guardians and Wards Act in case there is a fight between the parents for custody. Now herein it has to be taken care of the fact that paramount interest theory, paramountcy of interest of the welfare of the child. Nothing else holds importance. It does not matter whether the mother is right, the father is right, the mother is wrong, the father is wrong. None of this matters. All that matters is where would a child be able to be raised in a better, healthier manner, where would a child be given more love, affection, and even certain basics like education, maintenance, etc. So in this case, the Supreme Court has categorically stated that the well-being of the child or the welfare of the child does not only mean the pecuniary welfare of the child, but also with respect to morals, etc. Where are those morals, etc., or the other kind of upbringing is going to be better imbibed into the kid. So in this case, even in the case of Maju versus Maju, the Supreme Court had said that even the comity of court principle does not apply when the paramountcy of interest of welfare of a child comes into the picture. So essentially the Maju versus Maju was a case in which the couple was living in America and they were both citizens of America, and one of the father had basically the father had got the custody of the child, and the mother came to India and applied to the Supreme Court for the custody of the child. In this, the Supreme Court stated nothing else matters but only the child's welfare matters. So in this case also the child's welfare, as it was determined by the Karnataka High Court, it was with to stay with essentially the father and not the mother, and the mother was refusing to give up the child. Therefore, the remedy that the essentially the court could adopt was that the court could allow attachments, the court could at a certain later stage could allow any kind of arrests also. But here in this particular case, the court asked the mother's employer to stop salary. So she was working in a private firm, and the salary was stopped or essentially attached till the time she does not hand over the kid to the father. Next we come to DNA test on child. This is a judgment by Justice Pushpendra Singh Bhatti. This is judgment of Rajasthan High Court. DNA test on child to prove wife's adultery should be done only in exceptional cases. So if you talk about DNA testing to ascertain the paternity of the kid, this is not a very new technique. It has become now a very old technique. But at the same time, we have seen the trend of the court that it has always been a little apprehensive and reluctant in adopting these kind of technologically advanced or scientific theories, etc. At the same time, if we ascertain how a paternity of a child is to be determined, there are certain things that are to be taken care of, and there are certain things that all the courts, the Supreme Court directed that all the courts are going to ensure. First thing is section 112 of the Evidence Act comes into play, which states that in the whole duration of subsistence of the marriage, that is from the point of solemnization of the marriage till the point of the culmination of the marriage, that is till the point the divorce decree comes into the hands of both the parties, then during that time it is essentially a well established law that if a child is begotten out of the mother or out of the wife, it will be presumed, the court shall presume, it is a rebuttable presumption of law, the court shall presume that the father of the child is a husband. In case he wants to rebut this presumption, he can show non-access at the time of conception. But at the same time, this is the law that is generally followed. The Evidence Act was written a long time back, and now we had certain advancement. We can tell the paternity of a kid by DNA testing, etc. But at the same time, the Supreme Court time and again has been telling to be conscious about DNA testing and the effects of it, the effects that the child is going to basically have on it. So it stated it is high time with respect to DNA, it is high time that the society and law realize the importance of the child and childhood. Essentially, it is high time that the society realizes the importance of child and childhood, the welfare of the child. Here also they are not concerned about the paternity of the child and the legitimacy of the child, etc. They are only concerned about the welfare of the child. Vis-a-vis the matrimonial disputes, and losing and winning in marriage is having dwarfed impact when it compares to losing of a childhood in terms of victimizing the child or sacrificing his constitutional right of dignity and the altar of matrimonial conflicts. It is a very important sentence that the Supreme Court has now stated, that we have to ensure the fact that whenever there is a nasty fight, a contest, whatever, between the husband and the wife, and the wife's the legitimacy of the kid is challenged. Now the legitimacy of the kid is challenged only to cast aspersions on the wife, which might or might not be true. But you have to consider the impact that it is having on the child. Basically, the child is losing his childhood. The child is going to be what the Supreme Court stated as bastardized, and that is why he's going to lose his childhood. He's going to even lose his constitutional basically right of dignity under Article 21 of the Constitution. So the courts have to be mindful, and DNA basically reports, DNA test cannot be allowed in all cases. Earlier before this, in Deepanvita Roy versus Ranatobra Roy, this was a case of 2015, the Supreme Court had kind of tilted in the favor of the DNA test, etc., stating that DNA testing is the most legitimate and scientifically perfect means which the husband could use to establish the assertion of infidelity. So, infidelity could be determined by this kind of a test. This should simultaneously be taken as the most authentic and rightful correct means also with wife for her rebuttal, for her to rebut the assertions made by the respondent. So that she has not been unfaithful, adulterous or disloyal if the appellate wife is right. So essentially, in Deepanvita Roy versus Ronatobro Roy, the court had earlier sided with the DNA testing because it was saying that this kind of an scientific advancement is advantageous, to both the parties, essentially the husband also and the wife also. The husband, if he does not have to take care of a kid that is not essentially his, and at the same time the wife, in the sense that she will be able to, if she has not been, if she is not indulged in infidelity, then she'll be able to better prove her case in the case DNA filing is, DNA testing, etc., is allowed. But at the same time, there was a following case, that is Bhabani Prasad Jana versus Convener Secretary Odisha State Commission for Women and Others. In this particular case, the Supreme Court, the Supreme Court stated a slightly different thing. Let's see what it stated. It stated, in the matter where paternity of a child is an issue before the court, where the paternity has been asked, DNA is an extremely delicate and a sensitive topic. One view is that when modern science gives means of ascertaining the paternity of the child, there should not be any hesitation. So one theory, as we saw in Deepanvita Roy versus Ronatobra Roy, that if the science is allowing you to do so, then why not? It is a better way to ascertain the paternity. But at the same time, the other view is that the court must be reluctant to use such scientific advances and tools which result in invasion of the right of privacy of an individual, firstly, and may not only be prejudiced to the parties but also are going to be working against the child. Sometimes the result of such scientific test may be to bastardize an innocent child, even though his mother and her spouse were living together during the time of the conception. So that is why DNA in a matter relating to paternity of such child should not be directed by the court as a matter of course and routine in the manner whenever it is, every time it is so asked. So essentially, in Bhavani Prasad Jana versus the commissioner of, basically the commissioner in Orissa, in this particular case, it showed the same approach that the Rajasthan court has shown now. Now coming to our last, last case, law does not recognize live-in relationships as marriages, as married couples living together by virtue of agreement can't seek divorce. So basically, in this, the court essentially reiterated what has been earlier said by the Supreme Court as well. This is a case of X versus nil because the party's name were not supposed to be disclosed. So Justice Mohammed Mushtaq versus Sophie Thomas stated that you cannot essentially seek divorce in the case of a live-in relationship. A live-in relationship is essentially a relationship that earlier had not been recognized by law, but we found traces of it under the Domestic Violence Act of 2005. In Domestic Violence Act 2005, Section 2, subclause F of the Act defines a domestic relationship to mean, it means a relationship between two persons who live or have at any point of time lived together in a shared household. Shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together. So here it categorically gave some advantage or some remedies to the women who is not only married to a certain person but also who is in a relationship in the nature of marriage. But also the Supreme Court has at the same time defined what is a relationship in the nature of marriage, that yes, it means a live-in relationship, but it does not certainly mean a walk-in walk-out relationship. It means a relationship in which the two parties have been living together for a considerable amount of time and are deemed to be husband and wife by the society in general. So this would mean a live-in relationship, but at the same time, the live-in relationship does not change the factum valid of the case. And the factum valid is that if the couple has solemnized the marriage, then only they are married. Otherwise, no amount of staying together or a live-in relationship is going to legalize the relationship in the nature of marriage. So that is why no matter how many years or how many in whatever ways a couple has stayed together, if they are not married, the couple cannot seek divorce. So this is all for today's video. Thank you and have a really nice day. If you do have any doubts, do write in the comment box, and if you are interested in covering any topic, you can suggest some topics also in the comment box. See